Good morning, good evening, and it's a great pleasure to be here. My name is Francesco Sindico, and I'll be the chair for this webinar. As some of you may know, this is a marathon, and a marathon can be very tiring. Not that I have ever done one, but I'm assuming it can be very tiring. So what we have decided in this session is to mix things up a wee bit. I've asked my kind speakers to refrain from using slides. So I do apologize for those of you who love slides, but we won't have any slides for the next hour and a half. And what we're going to do is something a bit more lively. But I'll explain this in just a second. Let me first introduce a bit the context and the speakers. So this session is titled The Role of Environmental Law to Address the Climate Crisis and Promote Sustainable Development. And it's one of the contributions of the IUCN World Commission on Environmental Law to this UNEP-led marathon, together with the other partners, such as ARIEL. As I said, my name is Francesco Sindico. I work for the University of Strathclyde in Glasgow. I'm also working for Scottish Government as the Carbon Neutral Islands Project Lead, but I'm also the co-chair of the IUCN World Commission on Environmental Law Climate Change Law Specialist Group, together with Fabiano de Andrade Correa, who cannot join us today. A number of our speakers are also affiliated to the specialist group and actually lead some of our exciting projects. The specialist group was led until very recently by the WCL chair, Professor Christina Voigt. So I am following very big shoes, if you want to put it like that. But Christina is always so kind to help us and to advise. I have a number of projects that are in the pipeline and others that have already started with the previous edition led by Christina. One of the things we do have done, which is new, is we have created a network through LinkedIn in particular. And this network has now more than 160 members, and it's very active. And I know that amongst the participants, we have my colleagues Aditi Sheite and Manon Ruby, who later on in the chat can put their emails and their contact details in case you would like to join the network. But let's move on to how we're going to do this today. I've given two key questions to my speakers, and I asked them to engage with these questions for between, roughly 3 minutes, but I will be generous if you want to speak just a wee bit more. And then the floor is yours. Then I want those amongst the participants in the audience to really join in and using the Zoom features, the Q&A, to ask questions which I will then pose to our speakers. We'll do this for the first question. We'll then have a wee break. If you want to get a coffee or something, you can move out. There'll be a bit of music, some video, and then we'll move on to the second question. So what are these two questions? The first question is, what is the role of environmental lawyers in addressing the climate crisis and promoting sustainable development? So this is very much about us as lawyers, us as environmental lawyers. As I will explain very briefly, we have an amazing set of speakers with different backgrounds, with different life experiences. So in their answer, I would love to hear a little bit of also their personal journey and how they feel themselves as environmental lawyers can address not just the climate crisis, but simultaneously also promote sustainable development, because that's really the challenge I think we have here. We look at that question. And then the second is, what are the main legal tools in addressing the climate crisis and promoting sustainable development? So we zoom in a little bit in the second part of this webinar, looking at specific legal tools that our speakers have used, have observed, appreciate, maybe criticize, again, in the simultaneous battle against climate change, the climate crisis, but also promoting sustainable development. So who are our speakers? Our first speaker is Claudia de Wind. Claudia is an international environmental lawyer and expert in political sciences with expertise in the UN and Inter-American system. She's the chief executive and founder of the Inter-American Institute on Justice and Sustainability. So it's a real pleasure, Claudia, to have you here. And I do apologize for the very ridiculous times that you have there. I will introduce everybody, and then I'll give you the floor, Claudia, with the first question. Our second speaker is Stephen Minas. Stephen Minas is a senior research fellow of the Transnational Law Institute of King's College London, and also a very welcome member of the specialist group and of the IUCN WCL. But Stephen is also the vice chair of the UNFCCC Technology Executive Committee, which serves the UN Climate Convention and the Paris Agreement. Stephen, it's a real pleasure to have you with us. Our third speaker is Sarah Mead. Sarah is a senior legal associate at the Climate Litigation Network, a project of the Urgenda Foundation. And just like Stephen, Sarah is also part of the family of the WCL Climate Change Law Specialist Group, where she leads a project titled the Judicial Handbook on Climate Litigation with our colleague Margarita Veverinka Singh. Sarah, it's an absolute pleasure to have you with us today. And moving to Margarita. Margarita is an assistant professor of public international law at Leiden University, and she also collaborates as an adjunct senior lecturer in environmental law at the University of the South Pacific. And she's an attorney at Blue Ocean Law and co-leads the same project that I just mentioned with Sarah within the WCL Climate Change Law Specialist Group. So Margarita, an absolute pleasure to have you here. And last, but definitely not least, we have Fatima Hossein. Fatima is a doctor in constitutional law. She's a specialist in administrative law, lawyer, magister in virtual environments of learning, and she hails from Venezuela. So Fatima, thank you very, very much for joining us today. These are our speakers, but we are also truly blessed and lucky to have at the end of this webinar, for some wrapping up and some last words, our colleague and friend Ayman Cherkawi. Ayman is the coordinator for the Mohammed VI Prize for the Climate and Sustainable Development, as well as Strategic Development Officer at the Mohammed VI Foundation for Environmental Protection. And Ayman is the deputy chair of WCL, and I'm delighted to have him here with us. So, with all those presentations done, let me now pose again the first question. First question is, what is the role of environmental lawyers in addressing the climate crisis and promoting sustainable development? Claudia, I give you the floor, and I will then move on to the next speakers. Claudia.
Thank you, Francesco, for hosting us, and to all of you for being here watching this marathon. Definitely is interesting to start my day running at 4 in the morning. So I also want to recognize Ayman. It's really good to be, as a member of the steering committee, to see the specialist group in action and being a part of this important event. And going to your question, Francesco, these are very difficult times for lawyers. These are times in which we have to make difficult decisions. And I will say that, to start, in terms of my personal journey, I started my working in the legal field in the private sector, and then transitioned to an international organization, then started working in academia and working with the UN and the Inter-American system at the same time. I think the only thing I haven't done is being a part of an NGO, but now I'm in a private sector entity with a public interest, social and environmental mission. And I think that a key role that lawyers have today has to do with bridging, with connecting the different sectors and the different stakeholders to mobilize action and to address what the impacts of the climate crisis are. And part of that has to do significantly with understanding how the impacts of climate change look like. What is the face of climate change on people, and making sure that we can use the legal tools that we have at our disposal to make sure that we prevent, number one, number two, that we protect, respect, and remedy. As a society, it's clear that we have to adapt and we have to draw on resources from different disciplines of the law. And finally, you made me go back to my law school years. Well, you can't see, but I'm showing here a little book that is called The Soul of the Robe, that has the Decalogue and the 10 Commandments of the lawyer. And I think that we have to look at peace as a main triumph with all of the crises that we're facing today that intertwine with climate change. Conflicts are rising, specifically in the region where I come from. So I think peace must be at the center, together with justice. And what does justice mean? Justice in a broad sense of the word, taking into account that the benefits and the responsibilities with regards to the environment and what climate change means in terms of ecosystems, water security, extreme events, and how that affects people can be addressed, not only making sure that the rule of law is at the center stage, but at the same time that there is legitimacy, seeking that balance between what is legal and what is right, looking at justice with sincerity. I will leave it at that. Thank you, Francesco.
Thank you very much, Claudia. And before I move to Stephen, you mentioned the rule of law, and obviously this marathon is all to celebrate the environmental rule of law. But I do think throughout the next hour, 15 minutes of this webinar, we should all consider, and feel free to use the chat to put on your own perspectives. Over the last 50 years, have we strengthened the environmental rule of law? Have we consolidated? Or for whatever reason, has it been weakened? I just leave it there for both panelists and members of the participants to reflect on it. And obviously I wink to Ayman because at the end he will want to probably say a few words about the environmental rule of law. But let's move to Stephen now. So obviously Stephen has several hats, and one that is very fascinating is his role within the UNFCCC. But I let you answer the question, that is, what is the role of environmental lawyers in addressing the climate crisis and promoting sustainable development? Stephen.
Well, thank you very much, Francesco, and hello, everybody. And just as I begin, congratulations to the organizers for this fantastic initiative. The environmental rule of law is indeed our common aspiration and our common work. In terms of the role of environmental lawyers, I would suggest that there are at least two key words here. One, of course, is expertise, but the other is advocacy. And I think I'll start with expertise. We live now in a world which has been swallowed by the climate crisis. Every industry, every country, most areas of law and legal doctrine are in some ways challenged to respond to climate change at the same as societies are trying to fulfill the aspirations of their people for sustainable development. Now, what environmental lawyers bring to the table, of course, is our knowledge of how to secure environmental outcomes, protect environmental values through law. And that is something that we need to bring to the broader legal response to climate change. In a sense, environmental lawyers are challenged to move out of our natural habitat, out of our marine protected area, perhaps, and work in the transactional zone, work on disputes which are not what we commonly think of as environmental disputes, et cetera, and try and bring the knowledge we have of the tools of environmental legal protection. I'll have a bit to say about that later, but also work within larger teams to bring that environmental integrity to transactions, to disputes, to negotiations. I mentioned the UNFCCC. And of course, advocacy. And I think advocacy is self-explanatory, but I would suggest that advocacy is also internal, that within law firms, within legal professional bodies, within businesses and governments, for those of us who are in-house counsel, we are, in a sense, always representing the environment at the same time as we're we're representing particular clients, particular interests. And again, bringing this back to sustainable development, what we know from the last several decades is that climate action is not automatically compatible with sustainable development. So we need to be constantly looking for the improvement and the enforcement of environmental and social safeguards, including for climate transactions, climate projects. This has to be actively managed. And I think environmental lawyers have an important role to play there. So I'll leave it at that, and I look forward also to hearing from colleagues. Thank you.
Thank you. Thank you very much, Stephen. A lot of food for thought. I liked the way you brought in skills, the expertise, the advocacy. You talked about natural habitat of environmental lawyers. What is that natural habitat? You talked about how do we also and surely should always represent the environment. How do we do that? I may hint to Margarita with her own professional experience, which is obviously very much in that direction. But thank you so much, Stephen. I move to Sarah now, who also works very much in practice. So it would be interesting to see how she brings that conversation on. So Sarah, the floor is yours.
Thank you, Francesco, and thank you for the organizers for hosting this wonderful discussion. Organizing a 24-hour marathon is quite a feat, so well done to all the organizers. As Francesco has mentioned, I come to this discussion with two hats, so to speak. I co-lead a project with Margareta of the CCLSG, but I'm also a lawyer at the Climate Litigation Network, which is a project of the Urgenda Foundation. And it's that second hat that I'm going to focus on when I discuss this question that's been posed to us about the role of environmental lawyers in addressing the climate crisis and promoting sustainable development. And I wanted to start with just a brief quote from the latest IPCC report, the second working group, because I mean, in practice, we're always looking at these scientific facts relating to climate change, but this one really, I think, hits home and is relevant to discussing what our role is at this moment in the climate crisis. And it said, climate change is a threat to human well-being and planetary health. Any further delay in concerted anticipatory global action on adaptation and mitigation will miss a brief and rapidly closing window of opportunity to secure a livable and sustainable future for all. And I think that being in the summary for policymakers, which means all governments have signed that off, really, I think, shows the moment that we're living in. And I think with that in mind, when we're thinking about what the role of environmental lawyers is, but really all lawyers at this point, is to use every tool in the legal toolbox to demand accountability for the climate crisis and prevent further dangerous climate change. And in this particular presentation, I'm going to focus on one such tool, which is uniquely available to lawyers. And I think it's, we work every day with lawyers around the world who come from not just an environmental law background, but many different specialist areas to demand accountability, and that's climate litigation. And then in response to the second question, I can be a little bit more specific. But the global phenomenon of climate litigation has really taken off since the Paris Agreement. And I think that also is in response to some of the failings of the global governance system for addressing climate change. So since the Paris Agreement, there has been over 1,000 climate cases launched globally, and that is double the number that was filed before that date. And it includes a really diverse range of cases. And I think that's something to keep in mind when we're thinking about the role of environmental lawyers. These are not cases that are just being brought in environmental tribunals pursuant to environmental legislation. They're cases that are being brought in civil courts at international level, regional level, against governments, cities, decision makers, and also corporations. And so I think coming now to what the Climate Litigation Network does, we are working, the Climate Litigation Network was born out of the Urgenda case. The Urgenda case is quite a well-known case, which was launched against the Dutch government to demand the Dutch government to increase its mitigation ambitions. And following the success of that case, there was a lot of interest around the world from lawyers and communities and individuals to bring similar cases. And so the Climate Litigation Network was established and able to support those lawyers bringing those cases. So where individuals and communities were also in a position to bring litigation against their own governments for their failings, we're able to support them in bringing together the evidence they need to help them develop the arguments for those cases and so on. So while we're focusing on preventative cases against governments, there are also cases like the Shell case brought against corporations, and there's also a really important role to play in demanding damages for loss and damage suffered by climate change. And I'm sure Margareta is the expert in that, so she can always expand on it. But I'll leave it at that. That's a very whirlwind introduction to climate litigation. But I think it's something that in this kind of time of crisis, it's something that as lawyers, we can really reflect on how we can advance that type of legal action.
Thank you very much, Sarah. And I envision a lively exchange between our panelists as well once we finish this tour. I think one of the things you mentioned, obviously we're going to talk about the tools later on, but you did say one of the things we have to do as environmental lawyers is to use everything we can. So I would suggest that one of the things that is coming out, we have to be creative. We have to be bold. And again, I encourage those amongst the participants to share even their own examples of how they have been creative, how they have been bold, or how would they like environmental lawyers to do this. And can't think of a more creative and a bolder person than Margareta. So Margareta, the floor is yours.
Thank you so much, Francesco. And I'm so privileged and honored and excited to be part of this wonderful discussion and tour around the world. So of course we celebrate 50 years of environmental law. We do have some pretty impressive and potentially powerful environmental laws to use to protect humanity and ecosystems. We can take the UN Framework Convention on Climate Change as an example, which sets an incredibly ambitious ultimate objective of preventing dangerous anthropogenic interference with the climate system. It's a wonderful treaty, very well balanced. It encompasses the precautionary principle, the polluter pays principle, the no harm principle, the principle of common but differentiated responsibilities and respective capabilities. So there's also a sense of justice in this environmental treaty. And from that, of course, we have subsidiary treaties, the Kyoto Protocol, we have the Paris Agreement, which even refers to human rights as the first climate agreement to do so. So there's some really fantastic instruments. However, of course, while we celebrate the environmental rule of law, we also, I think most of us who care about the environment and the state of the planet also feel a sense of, well, a need for reflection and perhaps even a sense of worry, and it can be even desperation when we look at the facts, because obviously we have the instruments, but they're not working well enough at all. The climate crisis is so severe that I think many of us worry if we can even meet the temperature goal that is laid down in the Paris Agreement of keeping global temperature rise below 1.5 degrees, which is already a compromise. We shouldn't have to accept 1.5 degrees of warming. We're losing most of our corals already. It's inevitable. Sea level rise is going to continue no matter what we do. So we're in a very severe crisis, and then we're not even talking about the sixth extinction wave and all of the ecosystems, all of the biodiversity that has already gone lost and that we still almost bound to lose. So how can we turn the tides? How can we make sure that environmental law really delivers on the often beautifully articulated objectives? And here, Francesco, I think you're absolutely right that what we need is creativity, courage, and also collaboration. So when we talk about the lawyers, I think your point is also very important, Stephen. We all, we need to see ourselves as ambassadors, not only of certain clients or certain interests, but also of the environment. And of course, when it comes to sustainable development, there's more, it's not only the environment, but it is also of present and future generations. So thinking about justice, thinking not only about how we're not meeting the environmental SDGs, but also SDG 10 on equality, which is going very badly as a result in part of the pandemic. Inequality has increased terribly. So what do we do about it? How do we use our tools more effectively? And so everyone, of course, every lawyer has a different role to play depending on where she or he is located. But I think the sense of a conscience, environmental conscience, and also a social justice conscience is very important as a compass, no matter what we do, but as a compass to guide our decision making. And here we see, I think, inspiring developments in climate litigation, Sarah already discussed. And that's on the part of the lawyers, the activists, where you would more or less expect it, but interestingly also on the part of the judges, because to make the rule of law work for the environment, for the SDGs, for social justice, you need creativity also in how you interpret the law. And we see on the part of the judiciary that this creativity and courage is often there. And so, for example, Judge Shah in the Legari versus Pakistan case explicitly said that this overwhelming challenge of climate change calls for creativity and courage also on the part of the judiciary in really giving effect to these values that are embedded in constitutions, in treaties. And so that is not only environmental law, but also human rights law, the right to dignity, etc. And we see also increasing attention for the rights of future generations. And so just to wrap up, before we continue to the discussion, collaboration is critical because we're facing most of the challenges that we face. The environmental challenges are global in nature with local causes and effects, but the challenge is a global one and we have no time to lose. So as soon as there is a new invention that works well in one jurisdiction, it's useful if that can be replicated and used by others so that we do not need to reinvent the wheel again and again. So we see lawyers collaborating on climate cases, also now increasingly on biodiversity cases. And the same happens to an extent in judicial circles. So the project that I am co-leading with Sarah, which is the CCLSG project, and that you also refer to, tries to facilitate more collaboration and exchange between judges. We are using the WCEL's own fantastic network of environmental lawyers from around the world, who are in different professions, but what they have in common is exactly the sense of environmental ambassadorship, you can call it, what Stephen refers to. So everyone is contributing, all of these WCEL members who have agreed to work with us have helped us to collect best practice in judicial decision-making on climate change, collected all of this, the best practice. We have reported it, and we're now collating it into a judicial handbook, which we will hope will assist judges around the world to make robust, scientifically and legally robust decisions that can help us turn the tide on these terrible crises that we face. I'll leave it at this and so look forward to hearing the views, not only from the other panelists, but also from everyone who has joined us here from different places.
Thank you, Margarita. And feel free, either you or Sarah, to put in the chat maybe the link to the WCL Climate Change Law Specialist Group, that the project that you're leading. So you mentioned that we're obviously talking about environmental lawyers being creative and bold, but you also referred, for example, to judges having to be bold and creative. And one interesting development that just happened over the last few days was, and some of you may have seen it, is that in the German case, the Julia case, the German judge has actually gone to Peru and has done a visit, not just him, but also experts. And that's quite interesting. We can all have different views on whether that's the right course of action, but it does show that judges are not just sitting in their courthouses, in their benches, or whatever you want to call them, but they're actually, because there's a crisis, because they have to be creative, they take the initiative and actually go and feel what climate change and sustainable development actually looks like. So let's go to Fatima now, and sorry for arriving a bit late to you, Fatima, but please take some time to answer the question that is posing. What is the role of environmental lawyers in addressing the climate crisis and promoting sustainable development? Fatima, the floor is yours.
Thank you, Francesco, and welcome everyone to this.
I don't think we can hear you very well, Fatima. Can you speak either louder or closer to the mic, please?
Now you can hear me?
Still not perfect, but
I believe it's now good. It's okay now, the sound?
you can try, but try speaking a bit louder if you can.
Okay, I will try to speak louder all I can. The role of the lawyers today is very complex. They have to face many challenges, many changes. They have to combine not only the knowledge, the legislations, the practice law, but also the changes of the environment, the changes that the climate crisis is producing in every aspect of the life: health, security, economy, politics. Every area is combining, is united by the same problem, the same challenges. And the lawyers are facing that challenges, the problem to how to face that challenges, how to unite the knowledge and the action, how to reach to the people, to the business, to the governments. That is the biggest challenges that lawyers have today. Is they have to face challenges from what they study in the university, what they have know in the theory, the knowledge that they have been practicing as a lawyer. As a lawyer, they are involved only with legislations, with codes, with constitutions, with courts. But when they have to face the practice, the action, the reality of the problem of the climate crisis, there is when it came the biggest problem, and how they are going to unite, how they are going to combine the theory, the practice, the law, and the action. So that is the biggest challenges that the lawyers have in their role today. How they can do that, how they can reach to the people, how they can explain the consequences of their actions, how they can explain the sanctions, the criminal actions that they are committing against the environment and against all the living beings that live in this our home. So that is the biggest role and the biggest challenges that all lawyers have today.
Fatima, thank you very, very, very much. And I think this again brings to the forefront that there's not just one kind of environmental lawyer. There are different kinds, different areas. We work as counsel, be it domestic law firms, international law disputes. We work in academia, we do research. Some of us become judges or have trained as judges, but still there's an environmental law element there. And some of us work within more civil society patterns, let's say. But all of us have a role to play. Now, in the Q&A box, we have 3 questions. So I'm going to ask those questions, and I'll kindly ask the speakers just to raise your, not your virtual hand. I'm sick and tired of virtual hands, so just do like this. And tell me if you want to answer that question. But then also for the panelists themselves, feel free to jump in on any comments that our other panelists have asked. But I think the first question is important from Gibrilla Camara, because I emphasized in my question that this is about climate crisis and promoting sustainable development. So her question is very much along those lines. Implementing environmental law to address climate change requires a clear understanding of the linkages between sustainable development and commitments under the UNFCCC and the Paris Agreement. Can you please elaborate on these interlinkages for our better understanding? Clearly, we could spend 3 hours on this, so I do kindly ask you to be brief. But I remember myself, after following the Paris Agreement, I did look back and looked at the text of the Paris Agreement to see where sustainable development came in and so forth. If you remember, 2015 was very much when the SDGs were adopted as well. So there was a synergy both in the build-up. Is there a synergy in the implementation? Anybody want to jump in on this question? Yes, Claudia.
Thank you, Francesco. You know, I think this is a very difficult but important question that we must all answer, in particular because of the waves of climate litigation that we're seeing and how the Paris Agreement is being used. And I think that sustainable development and the interlinkages are in an integrated fashion across the text. One of the concepts, if you see what's happening in the judicial decisions that we're seeing today, has to do with this a carbon budget that we have globally, and what are the planetary limits that we have to live with. There are other key concepts that I think reflect the notion of sustainability and the 3 dimensions. One of them has to do with the concept of climate justice, and the second one with the preambulary text in which the WCL chair worked tirelessly on including human rights in the text of the agreement. And another aspect has to do with the balance between rights and obligations. When there are rights, there are also obligations and there are responsibilities that have to be carried through. There's a quote that I like very much, and I see the right to a climate free from anthropogenic dangerous interferences, as Margareta mentioned, that goes that rights are not something you serve on a plate to enjoy. These are things that you have to fight for in order to guarantee them and in order to have them. And the final thing I wanted to put on the table, and this has to do in a way with something that Stephen mentioned and your question about the rule of law. Yes, I think we have many laws out there, but when you look at the concept of the environmental rule of law as it has been developed in the past decade, are these laws adequate? Are these laws enforceable? And I think on the compliance and enforcement is where we have the greatest challenge. There are other things that build on this concept that include conflict prevention and management, accountability, human rights, and so on. So as Fatima was saying, it's very complex. And to Stephen's point, as lawyers, we have a lot of conflicts that we have to deal with today, and we have to ask ourselves very difficult questions. Just this week, I think there was a quote from the UN Secretary General saying, "Don't work for climate wreckers." So if we go back to our law school years and everybody has a right to a legitimate defense, and we know that one of the challenges, and I would say the failures of the environmental community, is that we have been preaching to the converted for a very long time. And a lot of work needs to be done with those climate wreckers if we want to see change and if we want to have a planet for our future generations.
Very happy you mentioned this. I'm also a firm believer that whether we like it or not, we need everybody around the table. And that actually our role as environmental lawyers, in the boldness and their creativity, is to actually create a table that works and not a table that falls apart. So thanks for that, Claudia. We have a few more questions, and because we talked about the sustainable development and climate change getting together, there is a question which again would require much more time, but it's from Dilip Sarma, so the third question on the list. And what I'd like it to ask about this question is that, in a way, he's asking that environmental law needs this integration, the clearly sustainable development, the three pillars, but that will demand lowest level of energy for sustainable development. And that's a big ask. That's a big ask. And I explain what I asked this, and then I'll give the floor to anybody who wants to jump in. Even in this country where I live now, in the UK, because of the cost of living crisis and everything, there's a big dilemma between climate change mitigation and energy security. And actually what's happening now is that one day the UK government will say, we're climate leaders in the world, but then the other day they will say, well, but we actually still need to deal with energy security, and we want to have our population, you know, in a better situation and develop, if you want to call it like that. And it doesn't really matter what kind of energy we use that. And that's ambivalent, to put it mildly. So again, anybody who wants to jump in on this question, you see it in the Q&A chat and it's full, but it's about how do we do that? Yes, Stephen.
Thank you, Francesco. It's a great question. I think the current crisis, which, let's speak frankly, has been significantly caused by Russia's illegal war in Ukraine, it just shows us that clean energy is fundamental to solving the energy trilemma. That you can have all kinds of short-term fixes that involve finding fossil fuel elsewhere, but ultimately the long-term solution has to be predominantly domestically sourced renewable energy, various forms of renewable energy, and that ultimately is going to deliver energy security, energy that can be afforded, and as well, of course, not burn the planet. So we're currently in a world, at least here in Europe, where there are these league tables of how much more expensive electricity has gone in different countries, and those countries at the top of the list, politicians are arguing. But the long-term solution has to be a massive shift to renewable energy. And obviously, that includes storage solutions of various kinds. We can't get there overnight, but I think if the current crisis has taught us anything, is that is a necessary part of sustainable development. And I mean sustainable in every sense of the word. Thank you.
Thank you, Stephen. There are two questions that will go together and can be geared maybe more to those of us who also work in academia and in practice. So I may ask Sarah, Margarita, and Fatima to join in together. So the two questions. The first one is from Jella Dutulu. She said, I'm a new lawyer. Where do you advise me to start if I want to be a productive environmental lawyer and maybe contribute to the world as a lawyer? I hope she takes maybe out. I hope she wants to contribute to the world as a lawyer. And then from my own colleague, Manon Ruby, she's obviously addressing all of you as currently practicing lawyers. And this is about how we teach, I guess. Do you think the way the rule of law is being taught has to change, has to evolve in order to address the climate crisis and promote sustainable development, as well as in order to shape the lawyers of tomorrow? So maybe in the order I see you in my screen, that it will be Sarah, Margarita, and then Fatima, if you want to say a few words about these two questions. Sarah?
Sure. So I'll also start with Manon's question. And I think the answer is it definitely has to change. And I think law schools have been really slow in changing. There's been this sort of inertia of delivering courses as they have always been delivered. And I think that has probably led to some students to sort of wonder, it must, quite frustrating that we're, learning law, but we're not learning how we can use it to protect both the interests of young people and the interests of nature and ecosystems and so on. And we're not teaching them how they can use those tools to advance climate justice and so on. So I think it's really, from my own experience when I studied law, law is often being taught abstract, in the abstract of any facts, and it's being taught in a manner which is as if nothing has changed. So it's as if, there isn't a climate crisis going on, and therefore there's a sort of, these questions are often posed as sort of an intellectual exercise, as in, can we apply these to the current, climate crisis, these laws, etc. But I think we need to go beyond that and think about how in this, and teach students how in this climate crisis, and teach the facts of the climate crisis, can we use the tools that we have available, and how we can use them creatively to address these issues of the day. And I think that requires academics, and to also invite people in practice, and to invite, a range of people working in different fields to deliver the courses, and deliver them in a way which is taking account of the circumstances and the environmental crises that are in front of us. But I think Margarita will probably, she's actually teaching students at the moment, as at Leiden. So you can probably expand on how that's happening today.
Yes, thanks, Margarita.
Yes, well, I wish my students were here, because I'm always very inspired by students who are, I think maybe, and I haven't been teaching for so long, perhaps to be able to say, but maybe more so than ever able to think boldly and outside of the box. And that is exactly what we need. And this also goes back to the other question that was raised about linkages between environmental law and sustainable development, the SDGs, the kind of core theme of our panel today. So it's about transformation, really. Everything, the whole economic system that still dominates societies everywhere, basically, is flawed. It really doesn't work. It's too much about profits, and everything else in a way is marginal, while what really should be central is right now the need for the transformation to a sustainable society that is not based on exploitation, but on care and regeneration. So how do we change that? And here, and this is a deep question, and it also for us as lawyers relates to the problem that Sarah raised about law being inherently conservative and kind of tailored to protecting the status quo, essentially. Well, what we need now is change. So how do we make the law work for these changes that we need? And there, I would say, whatever, it almost doesn't matter so much what you do, where you position yourself as an environmental lawyer. I would say, as long as you put your whole self into it, your mind, your full intellect, your heart, your body also, because I'm afraid that for many of us, we don't do enough self-care. So sustainability should work at every level, at the level of trying to change the world, and also in our own lives, how we relate to ourselves and others. So I think that is really important. And I see that young people understand that quite well, and that gives me a lot of hope, perhaps more so than anything else. And so I think just one more point to raise here is that, of course, we also do not need to take the law as it is for granted. We'll talk a little bit more about tools in the second part, but of course, the law can be changed. So that is also, and must change in some very important respects. So that is a big challenge that I think would be very useful for anyone who is starting to think about how can I best help the world, and the world, we can say, to address this challenge. And it depends then also on your personal preferences. So if you are someone who likes very deep thinking, reflection, reading, writing, then you may become an academic and write some books that can inspire a lot of people in bringing about changes. If you're more collaborative and you like to work as part of a movement, for example, an NGO, maybe a nice working environment for you. You may be attracted to working for government. There's so many different options. You may become a judge or something totally different. But whatever you do, I think it's really important to, as I said, bring yourself into it and also think very strategically about the scale of the challenge and what you can best do to make, to help us all make sure that international law and law in general is more aligned with the scale and seriousness of the challenge.
Thank you. Thank you, Margarita. There's a very interesting comment in the chat from our host from UNEP, Georgina Lloyd. She refers to the need for more experiential learning, for more learning in universities, at schools that actually touch real things, law clinics and so forth. And I truly appreciate that. And I'm keen to collaborate even further, both from IUCN and from my own organization with UNEP on this. But Fatima, a few words from you on these two questions, then we'll have a wee break and we'll move to the second question of this webinar.
I would like to respond to the second question, referring to guerrilla in Africa. Africa is very rich in every aspect: environment, legislations, people. Africa have important legislations on environment, institutions that work in the protections of every aspect of the environment. They have important movements. So if you want to work and develop yourself in as an environment lawyer and in the network that you have mentioned, you can create a combination of information, legislations, and communication with the people, communications with the community, with the politicians that can share and exchange information, problems, and how you can try to reduce that problems, that crisis, climate crisis. Africa have legislations that can guide you, the sentences, jurisprudences that are very important in that aspect. You have a very important project that is developing in Africa to create conscience, to create changes in that area. So take that document, take that project and involve that project into network, into experience. As a lawyer, every aspect, every information, every action that you can take is important, because that is going to contribute to the challenge, to transform that problems, to reduce that crisis problems that have Africa. And you can do it with that network, creating, incorporating, exchanging documents, information, and practices. Not only between students, also include the community, the people that live in that area and other areas of Africa.
Thank you, Fatima. And I see there are some other questions in the chat, but we won't have time to respond to them live now. But I do encourage any speaker who may have something to add to those questions to feel free to type your answer in the Q&A box. What we're going to do now is we're going to have a 1-minute break. I was hoping to give you more time for your coffee, but time is running. So I'll kindly ask in just a second our host to put on a video just for 1 minute. But please do use this minute, not only to get your coffee or whatever you want, but also, and this goes to the many, many participants in the room, to write your own answer to the question. The question was, what is the role of environmental lawyers in addressing the climate crisis and promoting sustainable development? Don't be shy. Get your pen or your your keyboard and write your own answer in the chat so we can all have a feel of what the participants have as an answer to this question. And I will kindly ask in now my colleagues from the organizers to just put 1 minute of the slideshow on the video, and in 1 minute we will come back. Please don't disappear. Okay, so I kindly ask the organizers to stop the video, please. Thank you. So thank you to Joy Heredero in the chat to answer the question, and hopefully we'll get a few more. So before we move on to the second question, I remind you, is more moving along the tools. What are the legal tools in addressing the climate crisis and sustainable development? Let me just share with you a few recent developments that relate in a way to tools, just to give some food for thought to our speakers. So just over the past 2 weeks in Europe, we had 2 countries that have passed new climate targets / legislation. The first one is from Finland, which is very ambitious, with carbon neutrality by 2035. But, and this I think is the important thing, enshrined in law. So the law, the piece of legislation is the tool if you want, but with an aim of doing more, not just carbon neutrality, not just net zero, but actually pushing forward after 2035. And then Southern Europe, Greece. This information has been shared by one of our network members in the Climate Change Law Specialist Group, which I'm very grateful for. A really interesting piece of legislation from Greece about climate change, which is not about only targets and emission reduction, but about tools, impact assessment, very strong focus on decarbonizing islands in Greece, which is something obviously I'm very interested in myself. You then have the Luya case, which I just mentioned, German lawyer going to Peru to actually see what's happening on the glacier and the lake that may create havoc in the region. We obviously have developments more intergovernmental. We have the Stockholm +50 just next week. We have the Lisbon Ocean Conference. A lot of things is happening. But all of this in the backdrop of what? In the backdrop of a COVID recovery, which I'm sure all of us use the words, we have to build back better. It gave us time to reflect. Are we really building back better? High levels of inflation, mainly in Europe, but surely other countries as well. The cost of living and the issues of fuel poverty. I see them here where I live in Scotland and the UK, which begs huge questions also from how we can deal with this and climate change at the same time. Stephen mentioned obviously the way forward, but it's not always that easy. And obviously, unfortunately, the war that is raging in Ukraine, but let's not forget wars also in other parts of the world. So I'll leave it to that, and I'll go back to Claudia. Obviously, because my time management is poor, we don't have as much time as I hoped we would, but I do kindly ask you to answer the question about the tools, and hopefully we'll get some time for some answers from the audience as well, before giving the floor to Ayman to close. Claudia.
Thank you very much, Francesco. I think that, as Sarah mentioned when we started this discussion, the toolbox is very broad. We have so many instruments that can aid environmental law. And in looking at the question, how it was posed, it was focused on legal tools. And I would say that, and here I will quote one of the speakers in today's marathon, that environmental law is a party and that everybody is invited, all of the disciplines. So many of the tools come from other areas that are not precisely environmental law. And one of them for me, and the most important, has to do with the best available science to address these issues. When we look at what's happening in the world in climate change, there are many questions related to attribution. There are many questions that are linked to tackling the uncertainties in which climate and environmental problems present themselves. And science can provide certainty and can provide the answers, aiding those that have to make decisions and that have a role in addressing the crisis. In thinking about this, there are tools that, as I mentioned before, have been incorporated into environmental laws. And some of these tools, and for me, the most important ones, are the preventive tools. Because for me, the nature of environmental law, it's preventive, is not necessarily of damages. When we have to seek damages is because we have not been able to succeed in changing behavior to drive the change that we need for sustainability. And some of those include the right use of environmental impact assessment, not just as a checkbox. And this has been also recognized by the Inter-American Court on Human Rights. Land use management, the incentives in the right place. There's a lot of use of voluntary and economic incentives to drive environmental change, but in many cases, these incentives are not placed in the right change and are not driving the behaviors that we need to have. And like that, there are many, but I will also, and then in terms of damage is of course restitution and compensation. But when we think about other tools, we need to include access rights, information, participation, and justice. And when we say justice, not only the formal justice system, but accountability mechanisms that are out there to monitor and support observation of safeguards in the context of investment and other areas. And to wrap up, I will say that when we are talking about access to justice and litigation, something that has been mentioned this morning has to do with creativity and drawing from the sources of law, the dialogue of these sources, the principles that we have in international and environmental law, in human rights law, to aid the work that we're doing on climate justice. Mechanisms like you've been mentioning the German case. How do we source evidence abroad? These are global problems. These are cases that are being tried in different jurisdictions where attribution and the origin and the facts are happening elsewhere. Mutual assistance and cooperation, thinking about conventions like UNCAC and UNTOC and so on. And the most powerful tool that I have encountered with in litigation is injunctive relief and the precautionary, the application of the precautionary principles in using those measures. Thank you.
Thank you very much, Claudia. And you really finished with what I was also writing down, the idea of an injunction, the idea that if we get to the damage, we arrive too late to the environmental issue. So how can we be, again, creative within a litigation setting, within another setting? How do we stop things before they get too bad? But obviously, you also highlighted the huge plethora of tools available, both national, domestic litigation, international negotiations. So clearly it's a broad question, but thank you so much for bringing all of that in. Stephen, what can you say about legal tools?
I'd like to add a couple of different tools which complement what has already been discussed. One of them is the development of appropriately rigorous contractual terms, including template contracts, template terms, which can then be built upon in a particular situation. Now, obviously, deal documentation is not necessarily the life of the party that is environmental law, but I would suggest that it is very important, because when we are trying to take these environmental objectives and mainstream them throughout the economy, we are dealing eventually with plain old contractual law. And it is something that environmental lawyers can bring to the table, and climate lawyers, to have appropriate rigor in terms of EIAs was mentioned, in terms of mitigation projects, external verification of mitigation, etc., environmental social standards, all of this. And all of this is responding to the conventions that we have. So just one example, of course, the Paris Agreement sets out cooperative approaches under Article 6. We had some very important decisions in Glasgow on that. And now a whole process is underway to develop standard contractual terms in the private sector by governments who are purchasers, project proponents for internationally transferred mitigation outcomes. And it really a great deal relies on those contracts being rigorous. So I think that kind of contractual work, even though it's not obviously environmental law, is incredibly important. And the other very low-tech legal tool that I would mention is the advice that we give to clients who are responding, sometimes with some urgency, to environmental legislation. So how do I comply with sustainability reporting? How do I comply with climate disclosure, and so forth? And our advice at that point needs to be, indeed, that this is not a box-ticking exercise, but we need to be talking about compliance, dare I say it, in the spirit of the regulation, as well as just how do I not get sued or fined. So I think that kind of advisory work, as well as transactional work, is a very important legal tool in this space. Thank you.
Thank you very much, Stephen. Before I move on to Sarah, I think one thing that you highlighted is how we cannot see environmental law in isolation. And I think it goes along with what Claudia said. I mean, if we just talk amongst environmental lawyers and just work within the realm of environmental law, we're doomed. I mean, as simple as that, at least in my opinion. We're not really going anywhere. So actually looking at contract law, looking at, I think one of the comments or questions was about criminal law, looking at investment law, looking at trade law, are all elements. And this also creates challenges, but also opportunities when you teach environmental law and so forth. So yeah, it just gets more complicated by the second in a way. So Sarah.
Yeah, so thank you, Francisco. I'm actually going to really draw on similar points in a way, but I'll just draw on them and give an example of how that plays out in climate litigation. So I'm really going to be drawing on my experience more as a practitioner in the field. So as Claudia said, to tackle these issues, we really need to draw on all norms from all different areas. And on reflection to the question earlier about how we teach law today, I think the silos are not helpful. So if you want to be a climate change lawyer, it doesn't make sense to just go study, environmental law, because what we're doing in these cases is we are drawing on every single strand of law to build out the standards and the norms that we need to succeed in these cases. So I think the first tool is that we need to be generalists in a way. We need to be across all of the different tools that we can use. And one way of sort of showing how that is the case is to look at the Urgenda case and the Supreme Court's reasoning in that case. So they ultimately relied on a provision of the Civil Code, extra contractual liability, to establish the liability of the state. But in interpreting the duty of care for that civil law standard of care, they drew on the European Convention on Human Rights. So in a way, the breach of the positive obligation was the wrong on the part of the state, and interpreting what the positive obligation of the state was in respect mitigation, they drew on a whole host of international law principles. So they looked at the precautionary principle, the articles on the responsibility of the ARIEL, so international state responsibility. They looked at intergenerational equity. So they were drawing on a whole host of international law environmental principles to determine the content of the state's human rights obligation to establish, civil liability. So there we see the huge range of norms that the court is drawing on. And as lawyers, we need to present and draw on all of those areas of law to establish, to build out our cases. And then I think, and one other really interesting development in that respect was how the court and how the court approached the Shell case. So in the Shell case, human rights, we are often taught at university that human rights only are relevant in relation to states and there are obligations only binding on states. But there we saw the court interpreting the content of the corporation's duty of care by looking and drawing on international human rights law. And that shouldn't be super surprising considering the human rights impacts of Shell's activities, but it is this sort of creative lawyering which enables us to think beyond the silos that we're sort of taught at university. And then the second tool that I want to point to, and it's more in a way, it's not really a legal tool, but I think it's similar to what Claudia said. We need to be interdisciplinary. So in bringing these cases and looking at how we can use environmental law, we need to talk with scientists, we need to talk with scholars, and we need to build out, we need to draw on them, because when you bring one of these cases, there's not one novel issue. Basically, every single issue is novel, and you're asking the court to start to move forward in many different areas. And so you can't just rely on precedents to say this is how you should answer this question. You need to look at you need to bring research from different academic fields, and you need to bring scientists and expert reports. And so in that respect, we can no longer just kind of hang out by ourselves as lawyers. And I think it's a real stretch for us because we're not taught to think scientifically, to be collaborative and interdisciplinary. But I think it's the challenge before us is to work with a whole range of people and to talk with people on the ground as well. We can only bring these cases if we hear how people are experiencing climate change on the ground, so that we can then relay to the court what the real impacts of climate change are and tell a story which emboldens them in a way to have the courage, as Margarita said, to apply the law in these sort of times of existential crisis. And so I think my key takeaway of the tools that we need to use is we need to be generalists. We need to follow lots of different things, and we need to draw on lots of different areas in order to advance the law and to advance the quest of climate justice. So I'll leave it at that.
Thank you very much, Sarah. We have just over 15 minutes for Margarita, Fatima's comments and some debate amongst us and the participants. So can I kindly ask Margarita and Fatima to be as expand but also as brief as possible. Margarita.
Yes, thank you, Francesco. And I agree with everything that has just been said. What I will just add for those few minutes is an international law perspective. And international law has I think, very important role to play in addressing the climate crisis and the other environmental crisis and promoting sustainable development, because some of the dimensions of the solutions that we need are necessarily international in nature. So when it comes to the very important issue of energy poverty that is raised here, so on the one hand, Africa needs energy to lift people out of poverty, and the same goes, of course, for low-income countries and areas around the world. And at the same time, we know that the carbon budget that we have is very limited. I mean, it's even almost, you can say, misleading to talk about a carbon budget, because we do not really have space to pollute any further. But so how can the sustainable development be promoted? And then we simply cannot do that without what is articulated in SDG 17 as a global partnership, international cooperation. International cooperation is at the heart of the United Nations, is at the heart of the Charter of the United Nations. It is at the heart of many environmental treaties, which also incorporate this very important principle that I just already mentioned, common but differentiated responsibilities and respective capabilities. So some states have contributed much more to these crises, the causes of these crises that we face today, than others. And these very same states have more capacity also to transition away from these causes and to deal with the consequences of these crises. So a treaty like the UNFCCC provides us a way to operationalize this principle of common but differentiated responsibilities. It is clear that developed states need to take the lead in mitigating climate change, as well as providing financial and technical assistance to developing states to also make a transition and to adapt to the consequences of climate change. And of course, the science supports this need for collaboration. Just a very important article came out on the long-term temperature goal. So it is still possible to limit temperature rise to at least well below 2 degrees and perhaps even 1.5. But it requires more ambition and also in any event, full implementation of all the nationally determined contributions that have been put on the table by states, the climate pledges that countries have made, including the conditional part of these pledges. What does it mean? The conditional part of the pledges are in the pledges made by developing countries are saying that we can do this and this to reduce emissions, but we need financial support in order to be able to do this, to implement this part of the NDC. So we need, all of that needs to be implemented in order for us to prevent really catastrophic climate change that would see the inundation of many low-lying island nations and just catastrophic consequences in the end for the whole world. So, and that requires that finance is really ramped up immediately. So right now there is, as those of you who follow the climate negotiations closely, developed countries have pledged to provide 100 billion euros annually by 2020, and still that pledge hasn't been met. And of course, post 2025, there are discussions now on the post 2025 climate finance target. It's high time that the climate finance target is based on needs rather than some politically convenient pledge. And with that, you really operationalize this global partnership, at least in one important area as it relates to SDG 13 on climate. Because there's so many co-benefits, of course, of doing that. It's not only that meeting these environmental and climate goals, but it's also about lifting people out of poverty, promoting gender equality, and all of these other SDGs, which of course also deserve attention in and of themselves. This is just one example from the climate front of how we really cannot see these areas in isolation. And so climate litigation, domestic climate litigation, unfortunately, up until today has not addressed this at all. There is not a single case that really is about the climate finance that is being provided by developed countries to developing countries. But this is something that is incredibly important and cannot be ignored. So I'll just mention one more initiative, which is the initiative of the Republic of Vanuatu to seek an advisory opinion from the International Court of Justice on climate change, and which is meant to be in a way a global initiative that involves all states and gives all states the opportunity to provide evidence about causes and impacts of climate change, but also about good things that states are already doing to address the climate crisis and to inspire each other and to inspire the judges to give some really helpful guidance to all states about what is really needed as per existing international law to deal with this climate crisis that has also so many social justice dimensions. And of course, yeah, I should mention and disclose that I'm involved in that initiative as the lawyer for Vanuatu, together with Julian Aguan and a few other wonderful colleagues.
Thank you, Margarita. Before I give the floor to Fatima, I have recently had the opportunity to act as counsel for the plurinational state of Bolivia before the ICJ. And it goes without saying that while I was in that building, working within international dispute settlement, my head did wander to what a climate change ICJ case could look like. We don't have time now to talk about it, but I do think it's a further tool in the toolbox, talking about that creativity, that boldness. And I think, Margarita, you would agree with me that a lot of this creativity and boldness is actually being driven by youth, by the young generations. And it's really interesting how they are developing it, and the role, especially within universities, that we have to work with them, our own students most of the time. So Fatima, last opportunity for you to answer the question about tools.
The environmental lawyers need to use all the tools that they can. That includes technology. Technology today is one of the most important and almost indivisible part of our life. Technology is in almost every activity and action that we make every day. So environmental lawyers need to use that tool to increase their possibilities to reach the major number of people, to communicate the importance of the protection of the environment. The social media, every action, every activity, every tool that exists in the technology can create that change. So we need to approach to people, to young people, young professionals, to all the people, the community, to that technology. So that technology help us to create that changes to fight and reduce the climate crisis.
Thank you very much, Fatima. So we have 7 minutes before I give the floor to Ayman. I'm going to be looking at the Q&A box. So it's more a comment than anything else from Agueda Silva about the need for adaptive rules, and that she suggests that this is happening in Portugal. So thank you, Agueda Silva, for that comment. Looking again at Manon Ruby, in the light of need for lawyers to be generalists, to use the entire spectrum of legal tools available, I'm curious to hear the speaker's perspective on the implementation of independent environmental courts. Some argue that environmental courts are, at the national level, for instance, relevant tools for efficiency resolving environmental disputes, yet it also stands in this legal tradition of isolating environmental from other areas of law. So again, if anybody of you who has had experience of countries where there are environmental courts, does that actually speak against this idea of using all the tools? Or in the specific domestic jurisdiction that you're available, has that led to some positive developments? I think some of these courts could be in Chile and India, if I'm not mistaken. I think Claudia. Yes, Claudia.
Thank you, Francesco. In fact, there are many specialized environmental courts and tribunals globally, a lot of them in the Americas. And I think that this is a topic that could take a whole, this is a topic that could take up a whole webinar. But I think what's important is not the medium or the venue. What's important is that we get specialized judges that are able to see the complexity of the challenges that we're dealing with, and that are able to be courageous, creative, and that are able to craft complex remedies for those challenges. There's not a one size fits all when it comes to environmental courts and tribunals. It will all depend on the context and what works for a different country or for a different situation and scenario. I will leave it at that because again, we would need a whole webinar.
This completes.
I am in the middle of a fire drill here, so hopefully it's finished. Yes, okay. That was the alarm that you were hearing, but it was just a drill. Thank you very much, Claudia. Is there anybody else who would want to comment either on that same question or broadly maybe just leading into what Ayman may or may not say about the environmental rule of law? These two questions, have they, in your opinion, shed light about the environmental rule of law? I asked at the beginning, has it been strengthened? Has it been weakened over the past 50 years? And while you think about it, just one comment from me, because a lot of people mentioned about finance, technology. I myself, now I'm involved in net zero implementation. And often, although this will apply more to some countries rather than others, technology is not really the issue. We have the technology. Technology is out there. Call it hydrogen, call it whatever you want. And obviously all technologies may have downsides, but the technology in some parts of the world is really not the issue. The issue ends up actually being what our skills are about. The regulatory patterns, the financial landscape, how we incentivize that, how we change those barriers. And it's a lot about these tools that we were mentioning. So I just wanted to put that in the mix. But before I give the floor to Ayman, do we have anybody else from the speakers, our excellent speakers from today, who want to say a few more words about either the independent courts or any other aspect that they would like to share with us? Yes, Stephen.
Just quickly, Francesco, to respond to your challenge about the environmental rule of law, it seems to me that on many measures, we have improved the environmental rule of law at the same time as the underlying environmental crises have got immeasurably worse, particularly climate change. So that, I think, is a paradox that we as lawyers need to think about and work out. We've heard about creativity today. I think we need a lot more of that, because whatever we're doing today is clearly not sufficient. So we need to be humble and we need to learn from others. And that also applies to how we implement the environmental rule of law. Thank you.
Thank you very much, Stephen. Anybody else? One last opportunity before I give the floor to Ayman. Okay, Ayman, I hope you don't mind if I give you the floor now and to say a few concluding remarks to this webinar, and I'll then, if you give me the floor again, I will wrap it up in a more formal way.
Thank you. Thank you very much, Francesco. Just to confirm if you can hear me. I believe you can. Thank you very much, Francesco. So on behalf of Professor Christina Voigt, who's the chair of the IUCN Work Commission on Environmental Law, I'm very happy and honored and excited to engage with you and to have taken part in this webinar. First of all, I would like to express our thanks to the organizers, UNEP and the Asian Research Institute for Environmental Law, and to also express our deep appreciation for the specialist group on climate change led by Francesco and Fabiano for their important work leading this conversation and bringing it forward in terms of these important concepts. Would also like to thank our speakers. Very happy to have had as one of the panelists, Claudia, one of the members of the steering committee of the IUCN Work Commission on Environmental Law. Also Stephen, Sarah, Margareta, who I've known for quite some time. Always happy to engage again with you, Margareta, as well as Fatima. Thank you very much for your comments, much appreciated. I also noted as part of the participants, various individuals that have been supportive of our work, as well as when it comes to this particular series of webinars, but also more broadly. So I saw Georgina connected from UNEP. She also reacted that important concept that that Francesco reacted to, also Robert Wabunoha, our friends from UNEP as well, also Damilola Olawuyi, among others, who are very engaged in this important field. I noticed Jibrila Kamara, who's quite engaged in the Montevideo Environmental Law Programme, and I think it's important to note that in the context of this celebration, we are also celebrating the 40th anniversary of the Montevideo Environmental Law Programme. Also very thankful, of course, to the technical team, such as the technical support, but also the translators. So I'll be very brief in terms of having express those thanks in priority. Typically, we end with those thanks, but I wanted to start with them because we're very particularly grateful to all of you. I wanted to connect to two elements. The first of them is Francesco and others reacted to the concept of marathon earlier. Just like others, the most I've ever ran was a 10K, and that was years ago. So I don't have particular experience in running a marathon, but I do follow a bit some of the most renowned runners. And one of them was my brother from Ethiopia, Haile Gebrselassie, who once said, when you run the marathon, you run against the distance, not against the other runners and not against the time. But I would contend that in the case of this particular webinar, we're running both the distance and against the time, particularly when it comes to climate crisis. And also, Francesco was experiencing a fire drill earlier. And that reminded me of this famous quote from President Jacques Chirac, who decades ago once said, our house is burning and we are looking elsewhere, when referring to the environmental crisis. And clearly this sense of urgency is something that permeates a lot of our work, while at the same time, the importance of being inclusive and engaging with all various stakeholders is important as well. In a nutshell, when discussing the role of environmental lawyers, when discussing the main legal tools, I jotted down quite a few keywords: the importance of bridging, understanding, importance of legitimacy, the fact that we'll be bringing expertise, our role of advocacy, whether internally or externally. We discussed safeguards. We talked about transaction, litigation, accountability, principles, justice, communication, balancing rights and obligation, compliance and enforcement. And I think in particular, the last one would speak to Christina in her role as co-chair of the Paris Committee to facilitate implementation and promote compliance. We discussed a whole series of important concepts, but I think at the end of it, to a large extent, we discussed about the box and the different tools we have in this box. We discussed about how the box is growing in terms of legal tools, but also we discussed the importance of looking outside of the box and acknowledging that silos are not helpful, and the importance of cross-disciplinary approaches. The last point, the second to last point I wanted to make is connecting to a concept that I believe emerged as well in the course of this webinar, which I would frame as this idea of cross-pollination of legal inventivity and invention when it comes to what we see emerge in certain jurisdictions and how we connect from one jurisdiction to the next in terms of this legal inventivity in a way, and also the acknowledgement that law can and must change, and how we connect that to our legal innovation, I think is particularly important to our ability to rise to the scale of the challenge we have in front of us. The very last point I wanted to make is an invitation that has two levels. The first of them is invite you to another session that we are organizing in the context of this series of webinar, this 24-hour environmental rule of law conference. Is the partnerships on environmental law partnerships to advance environmental law session later today, where another chair from a different specialist group, the biodiversity one of the World Commission Environmental Law, will be speaking. Jibrila, who I acknowledged earlier, will also be speaking as a representative of the Montevideo Environmental Law Programme network of focal points in Africa, and Robert Wabunoha will also be speaking. And beyond that, also indicate to you that the IUCN World Commission Environmental Law will be hosting in Oslo, as many of you already know, an international conference in early October, from October 3rd to October 6th. We did a call for papers, and we're very happy to have received several hundreds of papers that we're currently very busy looking at. And thank you very much for your engagement on that. Again, thank you to Francesco. Thank you to everyone for your brilliant work. Thank you.
Thank you, Ayman, for those closing remarks. The time has come up. We have discussed these two questions. I found it really fascinating to have this discussion. I do apologize for the time, especially for Claudia and Fatima, but hopefully now you're fully awake and you can join the marathon in its running. And again, a huge thanks to all the participants. I also saw some familiar names, but also some new names. I hope that many of you can join us in the IUCN World Commission on Environmental Law, Climate Change Law Specialist Group and participate in more activities like this one, both virtual, but also in person like the one in Oslo. And a huge thanks to UNEP and to ARIEL for their organization, their leadership on this marathon. I close it here, Georgina. I think that's okay. And the organizers will invite you to the next part of the marathon.
Thank you so much, Francesco. And thank you to all of the speakers. This has been an incredible session. And you guys mark the halfway point. You've run half the marathon. So we are now, we're 12 hours into our 24-hour celebration of environmental rule of law. And I have been awake for that whole 12 hours so far. So I might already be starting to look a little bit tired. But we have so much more ahead of us. And we have already heard so many incredible speakers. We started off in the Pacific. We then moved to Australia, New Zealand. We've heard speakers from across Asia. We had a fantastic panel earlier today on the role of women in environmental law. We've also been to the Middle East and North African region and had a fantastic panel there as well. So it is all recorded. If you do ever want to go back and watch the past 12 hours, you can do so. It will be posted both on the event website as well as on the ARIEL social media channels. Our next session starts on the hour, wherever you are in the world. And that session will look at the role of environmental human rights defenders to advance the environmental rule of law, an incredibly important panel. So many speakers have spoken about human rights and the environment, and we know that this is an area where there has been more of an interconnection over the last decade in human rights law, environmental law, and it's very clear that you cannot advance environmental rule of law without the protection of human rights. So please do join us for the next panel on the role of environmental human rights defenders. And to get us into the mood of that, we are going to have a quick video from the Special Rapporteur on Human Rights and the Environment. And then we will have a break and we'll be back on the hour. So thank you very much to the specialist group from WCEL, and we will see you and connect with you soon. Thank you.